Thank you, Dan, and thank you all for being here. Let me join in my thanks for the New England Legal Foundation for sponsoring today's event. And we're hopefully going to make this a rather lively event with some give and take and some questions. The format is as follows. We have 4 presenters today who will cover different topics in mediation, after which one of the panelists will ask a question of the presenter. And then at the end, hopefully we'll have some time for questions and or discussions as you please. All right, so my topic is Mediation 101. So mediation actually began, believe it or not, in 4500 BC in Mesopotamia. Does anyone want to guess what the population of the world was in 4500 BC? I was surprised.
1 million.
40 million people. It's kind of surprising. So in the Sumerian society, the Mashkus, who was the mediator, was required to go to the Mashkus to try to get your case settled before you can go to court, or whatever the court system was back there in 4500 BC. But the notion of mediation goes way back. It became popular in the United States in the early 1900s with a period of labor and social unrest and continued problems in those areas, and it became widely popular in the 1970s when our dockets in our civil courts became quite crowded. I'm sure you all know, but just to make sure we know the difference between mediation and arbitration, people get that confused all the time. In mediation, you have a mediator who seeks to get the 2 parties to voluntarily and consensually agree to a resolution of the dispute. In arbitration, you have an arbitrator acting essentially like a judge in a more informal process, with the arbitrator essentially deciding the dispute, him or herself. These days, almost every civil case involves mediation. Various court rules require it. Various agencies require it for disputes in their jurisdiction. Routinely, judges will require the parties. I say require it because it's not a formal requirement. But if the judge says, "I suggest you mediate," you should think of it very seriously. And in fact, the culture is that everybody mediates just about every civil case before taking it to trial. There's public mediation and private mediation. Most courts now have some adjunct facility to provide public mediation. Former judges that volunteer their time, processes that are available for free, and so you can make yourself available to those public mediation services. Most people don't use private mediation services, where the parties agree to split the cost of the mediator, and that's pretty much what we're going to talk about today. I want to take you through the chronology of a typical mediation so that when you hear the rest of our speakers speaking today, you can put it in a procedural context. Litigators always think procedure, trial lawyers think procedure. So let's start with, what is the chronology of a typical mediation? Well, it starts with a dispute, whether it be a demand letter, any other level of dispute that arises, but it more typically is the filing of a complaint and a lawsuit that will compel the parties to think about mediation. The first step is that however it comes up, the parties, the lawyers will get on the phone and say, all right, we'll agree to mediation. Who do you want to use? And there's a discussion about who the mediator should be. And that's a very important part of the process, and a big benefit to the client. When you're representing your client, you should really see to it that you get somebody who you are comfortable with and your client is comfortable with. Most everybody who's in the business, who's a litigator, knows they have their favorite mediators. You can go on Google or online, or you can go to advertisements in the Lawyer's Weekly, wherever, and you eventually agree on the mediator. Then there'll be an initial discussion with the mediator, and another important part of the process, at least from the mediator's point of view, is that initial discussion that you have with the mediator. Most good mediators will conference with each of the sides independently and find out what's going on in the case, what that lawyer sees the case as being about, and learning about some of the dynamics of the matter. Then the next step is the mediator usually has a practice of either requiring mediation statements or not requiring mediation statements. And I'll talk a little bit more about that in a second, but the mediation statement is what it sounds like. It's a brief recitation of the case sufficient for the mediator to gain sufficient understanding to mediate the case. Then after the mediation statements are filed and after the pre-mediation conferences are held, there's the mediation. Mediation is held in a room not too dissimilar from this. The parties will meet at least jointly sufficient to do a general overview of what the day is going to be about. And then you're going to hear one of our speakers is going to speak about whether to do more than that. That is, whether to do what's called a joint session, where each party presents their case, their side of the case, in a form that's joint. Everyone's there, including the mediator, and then you go on from there. There's a lot to it, more than you might think. After the joint session, whatever it may be, the parties then break out into breakout rooms. I mean, literally, physically breakout rooms. They're in different parts of the space, whether it be a lawyer's office or some other common space, and the mediator then engages in shuttle diplomacy, going from one side to the other. So I often say to my associates before we go into a mediation is, read the newspaper that morning because we're going to have a lot of dead time to talk to the client. Be up on your Red Sox and your Patriots news. And then that goes on for the rest of the day. Usually the morning session is about learning the case, the mediator is learning the case, maybe making initial proposals, and then the joke among mediators is that the real mediation doesn't start until 3 o'clock. I had a mediator who I've used quite often who jokes he's going to start mediations now at 3 o'clock because nothing really happens until 3 o'clock. So 3 o'clock you get down to your real bargaining, and hopefully by the end of the day there's a meeting of the minds on the terms of resolution. At that point, the parties will enter into an agreement, a mediation agreement, which is a binding, enforceable agreement that determines the terms and conditions of the agreement. Usually, in a business case especially, there'll be a commitment to a more fulsome agreement that sets forth some of the more details that you need to make sure that the meeting of the minds gets actually performed. But everyone does a mediation agreement because you're never going to remember what you actually agreed to, yet last week at the mediation. And that's the mediation. All right, let me talk a little bit about the mediation statement, the written mediation statement. There's a lot of strategy that goes into that, and we talk about how to use mediation to your advantage. Sometimes you want to do a mediation statement and share it with the other side, and sometimes you just want to give it to the mediator. And that's really kind of the second big strategic decision after who the mediator is in your case. And what I have found is, from the plaintiff's side, you want to do a mediation statement and give it to the other side if you have some damages that are more than just a number. Because if you don't do that, you start the mediation and you'll throw a number out, but it'll just be a number. If you have some elements to a claim, some damages that you want to lay out on a piece of paper, I find it to be very advantageous for the plaintiff or the party seeking relief to do a mediation statement that you share with the other side. All right, now let's talk a little bit about the timing of mediation, so-called early mediation. And this is a very hot topic with attorneys and mediators. Do you mediate a case right at the beginning after the complaint is filed or thereabouts, or do you wait until discovery is completed and then mediate the case? So let me talk about the factors that go into. Some courts, by the way, require you to mediate at the beginning. EEOC, for example, requires you to mediate at the beginning of a case upon the filing of a case. But most civil courts don't. So here are the factors. At the beginning of the case, you really don't know much about the case. You don't know the facts of the case. But more importantly is this. They teach you the first day of law school, trial practice is the facts aren't important. It's only what you can prove in court. So at the beginning of the case, you don't know what you can prove in court. You haven't deposed the other parties. You haven't deposed the key witnesses. You haven't seen the other parties' documents. So you really don't know quite what you're up against when it's early in a case. So you don't know the facts, really. Secondly, you're representing a client. It's very hard to advise the client when you don't know the facts. You're kind of shooting in the dark. It's difficult. It's difficult, and the client's going to look to you for some guidance, and you're going to be giving some advice without really knowing the facts of the case. The second dynamic is mediation is a terrific vehicle for discovering the facts that the other side thinks are important. Tremendous vehicle for discovering facts that the other side thinks are important. Because after all, in a mediation, you want to convince the other side to settle on terms that are favorable to you. So you're going to give them the good stuff. You're going to give them the good stuff. And you're going to get the good stuff. And you're going to know kind of what the other party thinks is important. And you're going to get those facts. And, of course, everything in a mediation is confidential. But that doesn't mean to say you don't know the information. And that doesn't mean to say you can't use the information in a deposition, for example, or in other discovery proceedings. So that's a very important advantage to an early mediation. You can get at the facts the other side thinks are important really quickly. The other thing you can discover is the lawyer's strategy on the other side of the case. Are they going to seek summary judgment? Are they going to seek some sort of injunction? What do they think some of their affirmative defenses are that are important? Again, that would help shape your discovery in the event that the case doesn't settle. Those are very, very important considerations. The other thing that I find is at the beginning of the case, the positions of the parties have not hardened yet. What happens during the course of discovery is people get angry. People get committed to their case. People get locked into hard positions. And at the beginning of your case is when your client is most open-minded about, maybe I didn't send that letter on time. It opens up more flexibility for some creative thinking by your client and the other client for some resolutions that you might otherwise not be able to consider after the parties' positions have hardened during discovery. The other consideration is, and clients underestimate this all the time, there's a reason why there's so many lawyer shows on TV. It's interesting. The cases are interesting, and especially when you're a party. If you're a middle manager in a company and your conduct has been called into a question, well, you're going to be thinking about that when you put your head on the pillow that night. And to do that for 2 years, it's a tremendous impact on your company. To be dealing with business litigation for an extended period of time. And businessmen always and women constantly underestimate the amount that's going to disrupt the profit-making venture of the business. And lastly, the big Megillah here, the 6,400-pound gorilla, is cost. When you resolve a case early in the case, you resolve it and save your client a boatload of money. Litigation is expensive. It's just expensive. It's just the way it goes. And if you can settle a case early, you're saving a ton of cost. And all of that cost can go into an offer or reduced demand to settle the case. And that really is the most important point. I guess I'm bearing the lead. But the most important point is early mediation really saves your client a lot of money.